case is entitled in the matter of Matthew Goorbold-Mcardle, plaintiff, and Brooklyn Page, respondent, case number 24 DM 256. Would counsel announce appearances, please?
Yes, Your Honor. Tony Jones for the petitioner, Matthew Goorbold-Mcardle, who appears in person.
Thank you, Your Honor. May it please the court, Riley Broyles appearing on behalf of respondent Brooklyn Page, who does not appear.
All right, thank you, counsel. Now, there's a couple motions pending. We've got a respondent's motion to set child support and other relief that's on the calendar for Wednesday morning. Mr. Jones has filed a motion to continue. And Ms. Broyles, it's my understanding that you're objecting to the court continuing that Wednesday setting.
That is correct, Your Honor.
All right, and Mr. Jones, what is the reason for the request to continue that Wednesday hearing?
Yes, Your Honor. As you indicated, that's set for Wednesday morning at 9 o'clock. Matthew Goorbold-Mcardle is a college student in the state of Colorado. He has been a college student throughout this process. And unfortunately, April 30th is a time when he is just not able to leave Colorado to come to Kansas for this court appearance. So we're asking for it to be set at a time when he can be available to come to town to participate in this matter, to set this.
All right, Ms. Broyles, and why are you objecting to the continuance?
Your Honor, this case has been on file since July of 2024, and no temporary orders were set at that time. So to date, there's been no child support, temporary or otherwise, set in this matter. Your Honor, my client is a single mother who lives in Augusta, and she is needing support at this point. Mr. Goorbold has not provided almost any support to this child. According to our child support motion that's pending, he has provided a $250 Target gift card back in, I think it was August of 2023, and otherwise has provided no support for this child. Your Honor, we filed this motion in March, early March. It was March 6th, and at that point we reached out to the court to schedule the hearing. We did copy Mr. Goorbold's then attorney, Mr. Ellis, on that communication in setting the hearing, and he did not respond to that. So if he had an issue with it being set at on April 30th, which is almost 2 months out from the time we actually set the hearing, he should have spoken up at that point. He didn't. This motion was filed over a month later, and now he's asking to continue it. So if he wanted it continued, he should have spoken up at that point. But Your Honor, continuing this out even another month is another month where my client is not receiving any support from Mr. Goorbold. She, again, is a single mother. She is working at the daycare so she can get subsidized childcare for this child, which means that she is making less than she could elsewhere, but she's doing what she needs to for her child, whereas Mr. Goorbold has not. And to continue this out would be an extreme prejudice to my client, who again is receiving no support from Mr. Goorbold at this point. And so we're asking the court to allow the hearing to continue, which has been again on file for nearly 2 months at this point, to continue as scheduled on Wednesday.
Mr. Jones, how far out are you requesting the court set this out if the court considers a continuance?
Judge, my client would be available for any time after, and I thought I put that, June 9th, 2025. So if the court wishes, I can respond to some of the things Ms. Broyles said in her statement.
Okay, go ahead.
Well, I mean, there have been at least a couple of orders entered in this case, Your Honor. There was a temporary parenting plan. I'm sorry, a parenting plan that was reached in mediation and an order entered on that. I called it temporary because by its terms, it expires in August. And secondly, there was an order of paternity that was entered in December of 2024. So it's Ms. Broyles indicates there's not been a temporary order, and that's correct, but there has been significant activity on this case since it was filed. Secondly, I appreciate that the mother in this case is now willing to accept help from Mr. Goorbold-Mcardle, and he's wanting to do that. That was not clear to him until this motion was filed. And certainly there's communications that indicate otherwise up to this point. So this is not a matter of Mr. Goorbold-Mcardle not wanting to help with the child's expenses. And I would dispute that there's only been one gift card provided by Mr. Goorbold-Mcardle on this matter as well. So again, our desire is not to delay, not to create a hardship, but to, as I said, Mr. Goorbold-Mcardle is a college student. He has summer employment. We think child support should be based on that. The petitioner's motion, or sorry, the respondent's motion indicates that he has not filed a DRA. That's not true. He did file a DRA with this court. We think his income should be looked at in what his actual income is versus the imputed income at a minimum wage from the state he's currently residing in. So there are some important issues that the court needs to consider, and I think it would be appropriate to do that in a manner where my client can participate in person and we can fully adjudicate the support issues.
I do note that the plaintiff's motion to set aside or vacate the order regarding custody and parenting time, that looks like it was filed on April 15th.
Yeah, that is correct, Judge.
I think what I'm inclined to do is order some sort of a temporary child support amount now and set this over to a time where all of these issues can be heard in court. But I think there does need to be a temporary child support order in place. I'm not sure why that wasn't done earlier when all the other orders were being considered, but have Miss Broyles and Mr. Jones, have you all had an opportunity to visit at all about resolving any of these issues?
I have not with Mr. Jones, Your Honor. I communicated at length with Mr. Ellis, the previous attorney on this matter regarding, we tried to, or I sent multiple offers regarding child support to Mr. Ellis without receiving any substantive responses back. So that's why there was a delay in between when we filed the journal entry to create paternity and permanent parenting plan and the time we filed our motion. I was trying to get this resolved without having to file a motion. I was unable to, and that's why I filed the motion in March.
Right. As far as this temporary support order goes, I know there's been some proposed worksheets submitted by Ms. Broyles, and keeping in mind that once the court's able to hear fully all of the issues, that can be retroactively adjusted. But I want to get a temporary order in place if we're going to set this over. Ms. Broyles and Mr. Jones, I could put you in a breakout room if you're willing to do so to see if you can come upon an agreed upon amount. If not, I'll just go through these proposed worksheets and set one as a temporary order. What is your preference, Mr. Jones?
I would be happy to speak with Ms. Broyles. I don't know that we're necessarily that far apart. It's my intention to file a response along with our proposed worksheets following this hearing, depending on what the court does. So, but again, I'd be happy to speak with Ms. Broyles about that.
All right, Ms. Broyles, any objection to visiting with Mr. Jones in a breakout room to see if you can come up on agreed upon temporary support?
No, Your Honor, I'm happy to confer with Mr. Jones.
Okay. I do have a 10 o'clock hearing, so if you all want to take a little time at this time, we'll take a recess.
Thank you, Your Honor.
Thank you, Judge.
All right, we're in recess. All right, we'll go back on the record, same appearances as before. Counsel, were you able to come to any sort of an agreement?
Judge, I think we may. I just need to get my client's approval on this.
Okay.
So I'm just going to ask him here in front of everybody. Matt, you don't have to do this. You can say no, but would you agree to an amount of $250 per month on a temporary basis starting, like, can we say May 1st?
Yep. That sounds good.
Okay.
All right. And Ms. Broyles, that's agreeable with you?
Yeah, it is, Your Honor. With
right.
note that if the effective date for May 1, we still reserve the right to go and ask for a retroactive child support under more of a permanent basis, if that makes sense.
Yes.
And that's what I had anticipated would happen, that, but I at least wanted to get something in place. So the court will establish a temporary child support order for Mr. McCardle, amount of $250 a month beginning May 1st, 2025. Next order of business is setting a hearing date to take up these two motions. We had a half day set initially, I believe. Well, actually 2 hours. How much court time do you anticipate it would take to hash all this out?
Well, I think it's as much as I don't want to do this, to me, it would make sense that we would perhaps set Mr. Jones's motion to reconsider before we take up the child support motion. Because if the court's going to set aside the permanent parenting plan, that might affect what child support would be. So if we want to do, we could do that. If we want to take up both motions, I do anticipate taking some evidence at that point, testimony. So maybe half a day, or maybe two hours or half a day would be sufficient.
What is half a day? Is that 4 hours?
Well, it depends if it's morning or afternoon. 3 in the morning, 4 in the afternoon.
I think
I
three in the
I
morning
would,
sounds good. Sorry, Mr. Jones.
I was just gonna say, I'm gonna err on the side of caution, and I'd like to have 4 hours, just 2 hours each side, I assume. So, because as you indicated, there will be some testimony.
All right, and your client's available after July or June 9th or July 9th?
I have down June 9th.
All right, well, Angela, what do we have for afternoon or a full day?
Judge, afternoon, I have July 1st. Full day, I have July 2nd.
I am free both of those days anytime.
I'm free either one of those days as well.
I'm inclined to just set it on that July 2nd full day. That way we've got it if we need it, and we wouldn't have to go over. And I would anticipate Mr. Jones, unless you object, taking up your motion first as suggested by Ms. Broyles, and then depending on the result of that, we can move into the child support motion if the parties are ready. Any objection to that?
No, Your Honor.
That
Okay,
sounds good, Your Honor. Thank you.
all right. Are there going to be any discovery being done? Do we need to establish some deadlines, exhibits, deadlines, and so forth?
I would ask for an exhibit deadline. I don't anticipate issuing any discovery at this point, but a deadline for exhibits and a witness list, possibly 1 week out, I think would be sufficient.
Any objection?
I would agree with that, Judge.
Okay. We'll make that deadline for exhibits and witness list June 25th by 5 o'clock. If you have more than 10 pages in exhibits, I'd request that you provide the court with an exhibit notebook.
Do you want these lists filed with the court or just exchanged?
Just exchanged. If you wish to file them, it's not a requirement. All right, any other deadlines you feel necessary, counsel?
I don't think so, Your Honor.
No, Your Honor.
And always I'll encourage counsel to confer prior to see if some agreements can be made amongst the parties regarding these issues. If not, we'll have that time reserved to argue them in court.
Your Honor, is that a 9 a.m. start?
Yes.
Thank you, Your Honor. And I can prepare the journal entry from today's hearing if the court would like.
Okay, I'll take you up on that.
Appreciate that.
All right, any other matters that need to be addressed today?
Not from petitioner, Your Honor.
I don't
Alright.
believe so, Your Honor. Thank you.
So just so everybody's clear, the setting for Wednesday morning at 9 o'clock is now being taken off of the calendar. And we've got the July 2nd setting. So,
Yes.
all right, if there's nothing further, we'll be in recess. Have a good day, everyone.
Thank you, Your Honor.
Thank you, Your Honor.
The petitioner Sherry Mosier does not appear. Respondent Nicholas Mosier appears by phone. Brandy Ridgway appears as counsel for DCF. We were last before the court on February 3rd. At that time, both parties appeared. Ms. Soretti was appearing for DCF. It was announced at that time that we just need to get the journal entry done from the March 19th hearing from last year, which was the party's parenting plan. I still don't see that an order has been filed adopting that parenting plan. Mr. Mosier, have you submitted anything?
I have not. I kind of gave that to her. It doesn't really benefit me one way or the other. She has not had an opportunity to finish typing that up, which is, I believe, what she said she was going to email you today, and would ask for another 30 days to get that in order.
Ms. Ridgway, it's my understanding, at least from the docket notes, that Ms. Soretti was going to journalize the child support obligation, but perhaps was needing the journal entry adopting the parenting plan to be able to do so.
Yes, Your Honor. Right now, the court-ordered parenting plan is for 50-50 shared custody with shared expenses. The proposed parenting plan gives the mother sole custody and allows the father, I think, every other weekend parenting time in the holidays is divided out. But based on the existing order, child support, would be shared, or I'm sorry, would be on a shared plan. And that's not what the parties seem to be exercising right now.
Okay. Well, the issue being, and I know DCF came into this after that had already been done, but it was announced on the record back in March 19th. We just don't have the journal entry from that
Okay.
done yet. So I think what I'm going to do at this point is we need to get this matter wrapped up. I'm just going to prepare an order adopting that proposed parenting plan that's in the file, and I'll do that myself. So
Well, according to my child support calculations, child support would be $952 a month based on that. I know the proposed parenting plan is that they share expenses, but since they are not sharing custody or sharing parenting time on an equal basis, the shared expense plan does not apply. It would be calculated based on the mother having residential custody. And the DCF's concern is that the parties' income combined is over $93,000 a year, but with their proposed plan of no child support, the taxpayers are footing the bill for the children's food stamps.
okay. All right, Mr. Mosier, anything you would add?
Yeah, I don't understand how they're even qualifying for food stamps. I'd say the DCF needs to drop the case.
Well, the problem is right now it's based solely on the mother's income with no child support being ordered, because that's what the current court order is.
Anything else, Mr. Mosier? All right, well, I'm gonna prepare the order adopting the March 19th agreement, which is the proposed parenting plan that was filed with the court on May 8th, 2024. And just so that'll put a bow on that piece of it. And then Ms. Ridgway, any recalculation that needs to be done can be submitted. And then if the parties want to litigate that further after that's all been done, then that'll be up to them to submit whatever appropriate motions.
Okay, Your Honor.
Your Honor, I don't fully understand what that means.
It means we've been waiting since March 19th of 2024 to have an order, a journal entry adopting what you all agreed to. And since that hasn't been done by either you or Ms. Mosier, I'm going to file the order adopting that so it can be done. And then the child support is what it is based on what you all have agreed upon as far as the parenting plan. And DCF is going to submit that order.
Does that mean that it changes from what we agreed upon?
I'm not sure how it will shake out in the end.
But from DCF's point of view, Mr. Mosier, yes, it will change. The law doesn't allow you to agree to a shared expense plan. So we'll be calculating child support based on the custody that you're actually exercising.
Then I would want to withdraw any of the proposed plan at all figured on March 19th. And I would say the plan is now 50-50 custody. The reason that we did this was because my parenting powers were taken away by the court themselves. And in order to get any parenting time, I had to get her to agree to a plan, which I did, at which point she basically quit paying her lawyer. Now, out of good faith, I'm willing to stick with the plan, but if it's changing, then no, I think it should be 50-50 custody. During this time, she moved the kids out of the town, to a different school. It put me in a position that the only way I could exercise my parenting powers was to pull the kids out of school for a third time and force my will that way. So in order to keep the peace, okay, I invented a way that was conducive to what I believe would be best for everybody. As far as food stamps and all that, I wouldn't even know how she'd qualify for any of that stuff. She makes as much money as I do. So I really think that there's whatever is going on with the SRS. I don't quite understand any of that. But at this point, no, I would not want this order to continue.
Well, it is what the court ordered. It was just never journalized. So I'm going to prepare the order adopting it. Then if you want to file a motion to modify that order, then that's something you can do, Mr. Mosier. It's just basically housekeeping, cleaning up what's already been ordered that's never been journalized and placed in the court file.
Okay. I mean, there's nothing I can, if that's what you're going to do, then there's nothing I can do about it.
I'm not going to set an additional hearing at this point. I'll get that order done and filed, and then Ms. Ridgway, if that gives you the information you need to file whatever you need to, then you can just go ahead and do that.
Yes, Your Honor. I'll file another motion and set it for a hearing on Judge Murfin's docket.
Okay. All right, if there's nothing further, we'll be in recess. Thank you, everyone.
Thank you, Judge.